You're watching The Legal Breakdown. So Glenn, this is the moment that we've been waiting for in the Florida case. Judge Cohen has dismissed that case, and now Jack Smith has finally appealed it to the 11th Circuit. So this thing is officially out of Judge Cohen's hands. How quickly can we expect this to be resolved by the 11th Circuit now?
It's a great question, Brian. I would think Jack Smith would ask that it be put on an expedited track, get it moving through the appellate court as quickly as possible. But, the flip side of that coin is I think everybody recognizes that there is no way this trial, Donald Trump's federal prosecution down in Florida, has any hope of going to trial before the November election. So it may be that Jack Smith no longer feels like, urgency is of the moment. And frankly, Jack Smith has other things to focus on right now. Not that he can't multitask, but remember, we're about to begin in the not too distant future evidentiary hearings in Donald Trump's D.C. prosecution for trying to overturn the 2020 presidential election. So it may very well be Jack Smith, who just filed his notice of appeal, and now the courts will order a briefing schedule. It may be that Jack Smith will not ask the 11th Circuit Court of Appeals to expedite this, but just to handle it in the normal course of business, because, now it looks like he's going to be turning his attention to Donald Trump's federal prosecution in Washington, D.C.
Well, in either case, when will we know whether or not Jack Smith is going to ask the 11th Circuit to expedite this?
We're going to know really soon, because I think the next thing we're going to see is probably an order issued by the 11th Circuit Court of Appeals saying, we are hereby directing the parties to submit briefs on X date. That will pretty much answer the question, okay, is the 11th Circuit expediting it? For example, are they going to give the parties 2 weeks to file briefs, or are they going to set a more leisurely pace, 30 days, 60 days, with an oral argument schedule to be set in the future? So I have a feeling we're going to know very quickly exactly what kind of a track this is put on, and it could come courtesy of a Jack Smith request, or it could come sua sponte, in other words, on their own, with the court just simply saying, okay, folks, 2 weeks from now, we want your briefs.
Does it almost not matter what the 11th Circuit says, since either way the losing side is going to appeal to the Supreme Court anyway?
It almost doesn't matter, but there are a couple of ways that it does matter. First of all, obviously it matters in substance, right? If you have a three-judge panel and they decide to rule firmly against Aileen Cannon's dismissal, as I would expect them to, and we can talk about why that is in a minute, it matters because in the event, for example, you have three experienced Court of Appeals judges who all firmly conclude unanimously, yeah, Aileen Cannon blew it again. She got it wrong. She abused her discretion. Those are magic words. We'll talk about why in a minute. But then the Supreme Court would have to find some kind of a way to unwind and unravel that kind of an opinion. What would it do? Well, if they decided to unravel and unwind what was clearly an opinion driven by the law, by the facts, by the Constitution, it will further expose the Supreme Court as the pathetic ideologues that they are, rather than being a court that has some loyalty to the Constitution. So it does matter. Now, let's take the flip side of the coin. What if they all said, you know what, Judge Cannon, you got it right. All of the other courts got it wrong when they previously said, yeah, special counsel is a thing, and the Attorney General does have the lawful authority to appoint one. That would matter too, because that would pretty much guarantee the death of this case. Because then I think it would be pretty easy for the Supreme Court to simply say what they said. What the 11th Circuit Court of Appeals said, we're going to go with that. Let me go back to abuse of discretion for a minute, because a three-judge panel of the 11th Circuit Court of Appeals previously concluded Judge Aileen Cannon abused her judicial discretion by doing something to the extreme advantage of Donald Trump that the law did not allow. Here is my, I'm going to say hope, maybe not expectation. If the 11th Circuit Court of Appeals looks at what Judge Cannon just did, which was really a borderline lawless act, dismissing this case for no reason that is supported in the law, if they say, you know what, there she goes again. She abused her discretion again. I have to believe that might actually be the straw that breaks the camel's back, and Jack Smith may say, okay, I'm not going to wait for a third abuse of discretion. I'm going to file a motion to remove her from the case and hope to have a fair, independent, impartial judge appointed to take over the case involving Donald Trump down in Florida. So I think the 11th Circuit Court of Appeals opinion matters in both form and substance, but I think your question is dead on, because ultimately the Supreme Court is going to do what the Supreme Court wants to do, as it has shown over and over again. What it usually wants to do is, do a solid for Donald Trump.
Glenn, can you clarify something for me? Because I am especially interested in the ways in which Judge Cannon could be removed from this case. But her being removed from this case would suggest that it would go to the 11th Circuit, for example, and then be, if they swat down Judge Cannon's ruling, that it would be brought back to the trial court. But isn't it not going to go back to the trial court, because either way, this thing is just going to get appealed up to the Supreme Court? So I'm having trouble figuring out which direction this thing is going to go in, whether it's going to go back to a trial court, possibly with a different judge, or to the Supreme Court, because in either case, one of these parties is going to lose. They're going to appeal.
Yeah, it's hard to figure out, the path a case like this takes, because nothing about this is ordinary or usual or has any kind of precedent to help us predict how this one might play out. But I think you're right. Listen, if Donald Trump loses, if the 11th Circuit Court of Appeals says, you know what, Judge Cannon, there you go again, abusing your discretion, and you're wrong, Donald Trump is going to file an appeal. Similarly, if the 11th Circuit Court of Appeals affirms Judge Cannon's dismissal, says, Aileen, you got it right, all those other judges got it wrong, Jack Smith is going to have to appeal that to the Supreme Court. So I think it very unlikely that this case will go from Judge Cannon to the 11th Circuit Court of Appeals back to Judge Cannon. It's not impossible, but I do think it's highly unlikely.
Well, Glenn, just a quick question on that. Do you think that it would be likely or even possible that Jack Smith would just say, look, before we even get to the appeals process here, before we even avail ourselves of the possibility of the Supreme Court, why don't I just recuse myself as special counsel, have a sitting U.S. attorney prosecute this case? Of course, it'll need to be indicted again, but at least we'll kind of remedy the issue at the heart of all this, which is, the supposed unconstitutionality of special counsels.
Brian, here's why that will not happen. Jack Smith and the Department of Justice will absolutely not make their next move by accepting a lawless ruling from Judge Cannon. We would confront this kind of an issue not infrequently when I was a career federal prosecutor. When you had a judge do something you knew was dead wrong, you had a decision to make, and here is how we termed it. Are we going to feed the monster, or are we going to fight the monster? Feeding the monster means, and I mean no disrespect to judges by calling them monsters, feeding the monster means accepting a lawless ruling, or a ruling that should be appealed, a ruling that is not consistent with the facts or the precedent, and just pivoting away and doing something else. That's wrong. That's feeding the monster. That is accepting and thereby tacitly endorsing a bad legal ruling. You can't do it. You have to fight the monster. You have to appeal. You have to use whatever legal vehicle you have to bring to the judge's attention, Judge, you're wrong. Judges are not always right, Brian. If they were, we wouldn't need appellate courts. And here's something else people don't often think of, I suspect. Appellate courts aren't always right, or you wouldn't need higher appellate courts like Supreme Courts. Jack Smith will fight the monster. Jack Smith will appeal it. But here is the other thing that I suspect is going on behind the scenes at my former professional home, the Department of Justice. They're putting a contingency plan in place because they know just how corrupt the Supreme Court is. There is rot at the top of the judiciary, and they know that. So what they are simultaneously doing, I kind of know it to my core. They are going hard after the appeal of this bad ruling by Judge Cannon, but they are also putting contingency plans in place quietly and behind the scenes, lining up a U.S. attorney and other prosecutors who can step in and take over this prosecution, thereby mooting out, negating, doing away with this alleged special counsel appointment problem. So, tactically, they know exactly what they're doing, and I think they're preparing for every eventuality.
In the event that they do have to re-indict this case with a sitting U.S. attorney as opposed to a special counsel, is it possible then that we could see another judge get handed this case aside from Aileen Cannon, since it would have to go through the entire process anew?
So beyond possible, I think it's likely. One, the odds are that it wouldn't go to the same judge, because the way these judicial assignments to cases are supposed to operate, it's supposed to be random. Just whoever happens to be the next judge up for an incoming case. So the odds are that it wouldn't be Aileen Cannon, but I have to believe Jack Smith has had about enough of Judge Cannon's lack of impartiality, and I can't imagine he would want to suffer the same, fate all over again by not filing a motion to have her removed, not filing a motion to have it appointed to another judge, a fair, impartial, independent judge, and I think that's what he would do.
Okay, so at the same time that this would be indicted, if the indictment moves forward, he would simultaneously issue a motion to prevent Judge Cannon from coming on to this case? Is that how it would work?
It would be an outlier of a motion, not something we do. But here's the thing. If we as prosecutors know when we are indicting a case and it's about to land on a particular judge's docket, if we know there's a conflict or some legal impediment to that judge actually accepting responsibility for the case, we can absolutely file a motion seeking that the conflict be recognized and that the case not go to that particular judge. You don't ask for it to go to some other, named judge. You just ask the courts to recognize the conflict and not assign it to a judge whose impartiality might reasonably be questioned.
But who ultimately makes that decision? Because we already know here that the chief judge in that circuit already recommended that Judge Cannon not take this case. So if that motion is put forward by Jack Smith, would it be the chief judge in that circuit who would ultimately decide whether or not Judge Cannon gets put onto that case again?
I believe it would. The chief judge has supervisory responsibility for all of the judges under her jurisdiction. Cecilia Altanaga is the chief judge in this particular federal jurisdiction in Florida. And I think she would have every right to say, you know what, I recommended that Judge Cannon not accept responsibility for the case the first time around. There was recent reporting on that. Now, as chief judge, I'm going to assert my sort of control, my supervisory control over my judges, my court, my jurisdiction, and I'm going to direct that it be assigned to another judge.
Copy that. Okay, well, obviously a lot of moving parts here and a lot that we are still waiting to find out as this case continues to progress into the 11th Circuit and beyond. So for those watching right now, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.